So I don't want to. There's such a universe of possible statements that could be made,
Dream.
but I don't want to try to.
All right, guys, we're there.
Rule
We're
in
here.
advance.
We're ready.
Refrain from doing that. I always
Let's
try.
go. I wasn't going to do the jury instructions because there's like 36 pages of them. But it looks like they may have a big throw out here.
At all, that it's unlawful to point a gun at somebody. Jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds.
Drop the provocation.
Well, why can't
he's going to drop the
direct them to
that they're not dropping the provocation.
Okay.
prohibit the state from saying it was waived at
Probably
the
take a
Zeminskis?
break after these.
Oh,
You were so close.
Oh God, Mark Richards, I hate you.
There'd been a really good
That
time
was
to
the-
renew that provocation
Yes.
objection.
So, yes,
Yeah.
just that was the entire basis for it, was that he pointed the gun at the Zeminskis.
Oh,
And
Yes.
So
At the
just
very
for
least.
for people, I've gotten a few questions. So count 6 was dismissed. That was the charge of possession of a dangerous weapon by a minor.
Yep.
So there's no there can be no allegation that he was not allowed to be carrying the weapon that he was, which is a huge win for him, because that would be a highly prejudicial charge for all of the other, especially in context of the provocation charge.
Yes.
And especially because everyone's been hearing that it was so wrong of him to carry this gun. It was illegal, that he was acting illegally. And now that's off the table. And that whole, anytime you hear from someone ever on the left telling you he was illegally carrying a gun, you say, you're wrong.
Nope.
That's just not true.
And
That's
by the way,
not a big comparison.
you could probably have heard Barnes shouting in the distance, because he and a bunch of others, Nick, you as well, have been saying it from the beginning. The crossing state lines was a lie, or was factually incorrect for those who didn't know it was. And now unlawful possession of a firearm, which people have been repeating from day one, is off the table and factually and legally incorrect. So two of the underlying premises of what made the conduct so over the top wrong have now been factually and legally disproven.
Good. There's been some cleanups here.
They've got to hit the fact that he was not illegally carrying a gun to the jury.
Yes.
Remind the jury, you've been told this whole time that he wasn't allowed to be there because of curfew, that he wasn't allowed to have his gun. We now know, as we've always known, that those were wrong. They were overreaches by the state, and he was legally allowed to be there and was legally allowed to possess his firearm. And guess what? That's probably why no cops even said a word about it all day long. In my opinion, you gotta remind the jury that he was legally allowed to carry that gun as much as possible.
big time. Because if you let it sit, if you just let it sit without more, they're going to draw the wrong conclusions. But if you really hamper you're right. People said he was wrong for being there because of curfew, because of illegal weapon. Both those charges no longer exist. He was allowed to be there. He was allowed to have that firearm. So you have to really hammer home that that's not provocation. If you really make that point home, then my odds of conviction are going to flip back over into the defense's favor. So it depends how well the defense doesn't close. But it was a potentially huge win for the defense if they can really make it work.
But still, that provocation is out there, though, and that's why they really need to hit on the fact that they should have moved to prohibit the state from implying to the jury that at any point that gun was waved at the Zeminskis, because that will be the ultimate crux of what the state wants.
They need to renew that objection.
I think they're going to object during, if they're smart, they'll object during the state's argument if they stray to it.
I think they need to be on their toes. They do.
I want to add something. Correct me if I'm wrong. The judge also indicated that he might still give a limiting instruction as to that freeze frame pinch and zoom video, right? Because of the whole jump science issue.
I think there is a limiting instruction. That's
Why is there no
in there.
picture?
Yeah, that's in there.
Yeah.
That would be interesting to see what he actually says about it.
People are asking about, and I'll know nothing about this, the idea of malicious prosecution now. If the DA
Fry's awesome.
a criminal charge that they abandon after 2 weeks of trial.
Well, you lose that on the complaint, right? Because the complaint itself was legally sufficient to go to trial, right? So they only the bar is probable cause, right? You have probable cause. So
as my memory of the case law serves,
have it.
I think I'm trying to remember if as long as you have one ground, whether or not you can get the malicious prosecution or not for the other grounds. I'm trying to remember the case law.
And you have to remember, they're trying to take a different interpretation of the law. They lost on that. The defense's interpretation was the one that carried the day. So saying, hey, this is how we thought the law was interpreted, they're never going to find malicious prosecution on that.
That's right.
The-
Internet
the
loved that
worst-
one.
The most egregious part to me was the fact that they had no dispute that the gun barrel was length was an issue, and yet and
Yeah, I didn't
they
understand
knew,
why
the
the
judge told
gun
them
barrel
on
length would be an
Friday
issue.
that was
Like,
the
it's so
only
obvious that
issue.
these people aren't gun
They
people.
were not disputing it. But
I've
they
got
were
a
gonna go to jury anyways. That
theory in
was a
politics
stick move.
that
bad faith.
when you are trying to choose a candidate to support,
What you are to
you always
follow
go
in
with the one
considering
that's the
evidence
most
and the evidence
pro-gun, most
It is
pro
your
Second
duty to
Amendment.
follow all of these
The reason why is because
instructions,
everything
regardless of
else
any
then will
opinion
naturally
you may
fall
have
in
about
line
what
with
the law
how
is or
your
what the law ought to
beliefs are.
be.
They're
You must base your
critical
verdict on the laws
thinker that are
identified
into
in these
details.
instructions. Apply
And
that law to the facts in the case which have been properly proved by the evidence.
when you don't have,
Consider
I mean, like
only the
it just goes with this
evidence
too. Like you really need an
trial, and the
extremely
law is given to you
pro-gun
in
attorney,
these
people that have been out there and
And
know
for
this
these
stuff.
things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has,
I'll try to
any
put a
question,
Jericho.
my opinion as
It's
to
a
the innocence or guilt of the defendant,
940 back together
must
right now.
disregard
See,
that
this
impression
940.
entirely.
See, I'm a horrible
Decide this case solely as you view the
expert.
evidence. You are the sole judge of the facts.
Horrible
You are
expert.
the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as
Okay, so the
evidence
jury's in there now.
in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As and I might interject here. Count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts.
First 5
self-defense
counts.
is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts, and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also.
Oh, he was running from the guy.
Provoke the attack.
I mean, this is
Person who
what so
engages in
drives me
unlawful
nuts about
conduct
it.
of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack.
That's it. The person who
However,
provokes the
if
attack.
the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm.
Wisconsin does not have a stand your ground law.
Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed.
That's
The
where
act
premeditation
need not have
becomes
been
difficult to
brooded
define.
over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct
That's gonna be the
means
hard
the
one.
conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
These instructions are kind of confusing.
Even for the
It's harder
judge.
when you can't read them.
It is
Shout
hard
out
when you have to flip through the pages.
People.
Yeah.
Shout out to my Odyssey people. We got 400 people watching over on Odyssey also.
There are
Thank you for
36 pages of
supporting Alt
instructions.
Tech over there as well.
Viva, I appreciate your ability at understatement there.
I mean, but the jury's going to have to take away a bottom line here. Even with the reckless endangerment for which McGinnis testified, I think that he didn't feel threatened, that it still can be justified under self-defense. I mean, bottom line, they have to understand.
But actually, they don't, because if they find him justified in Rosenbaum, then even if they find him guilty for the beginning, it's legally inapplicable. Like because of the way it is, it's just they're gonna throw it out.
They should be able to motion for a JNOV on that one. Like the jury just doesn't understand the law.
JNOV,
I'll be right back. I have a
don't-
puppy that
It's
needs
a
to go outside
judgment
again.
notwithstanding a verdict.
Okay.
Which basically means setting aside whatever the jury decided, and the judge acting on his own.
That no reasonable jury could come to the legal conclusion based on the facts that are present.
No, just like the idea of homicide.
Yeah, the makeup of the jury.
Administer first aid.
We
and all the
do.
evidence
There's
is
a thing I saw. It
putting
was
out
a
fires,
complaint
administering
about
first
how
aid, and now they're going to say that he had the malicious intent to
only
kill. I don't see any reason why a jury
one
getting
person of
even especially
color,
with these
I think.
instructions.
That's how the article went. I'll see if I can find
Yeah,
that.
and I
I've
played-
got
I
to.
played
I've
duck
got
growing
a
up,
little
so,
puppy
the
dog
wanton disregard
pounding
for
at the
duck-
door
duck
to
lives.
go outside. So let me get that real quick.
Hernandez also testified that he did not feel threatened by Rittenhouse as well, correct?
McGinnis.
But did not Hernandez also testify something to that effect? He felt threatened by the mob, by the riot, but
Yes.
not by Rittenhouse.
Maybe, but I would be suspect that the jury believed anything Drew Hernandez said because
Agreed.
he came across so overtly biased.
Yeah.
That
he was a little too willing to give friendly testimony, it seemed.
he was very hostile to the state's questions, like overtly hostile, and I think that came across. I respect him for standing up for what he believed was right, but I think it came across a little bit too brash, in my opinion.
He was a witness that should not have been there. They shouldn't have put him on. It was ridiculous.
Well, they could have tempered him down a little bit because there's a leitmotif and then there's just robotic repetition of rioters, and he was eager to continually repeat that leitmotif to the point where it became irritating to hear, even for those who were on the same side.
Nate, normally I would disagree with you saying he shouldn't have been there because he was necessary to lay foundation for the video, but we learned from the state that he actually wasn't. So I agree with you.
Rules of evidence.
Side, I indicated there were two elements. There are actually three. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are three elements to that crime.
Oh.
And I also used the word both of the elements.
You got to watch those paragraph
It's actually
breaks.
three. So I apologize for that mistake. And
They're gonna be like, we don't know what you said anyway. So yeah,
Yeah, read them to us
It's just-
again. We're fine.
we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are
The jury's not allowed energy drinks or coffee at this point. So
that the defendant caused the death of another, that he did so by criminally reckless conduct. And the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same three elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all three of the elements of first degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense.
There you go.
Is that clear? Thanks. Thank you very much.
Start from the beginning. I wasn't
Getting
paying
back to the
attention.
Absolutely
reckless
not.
endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum.
Needs a cough drop.
Coof
The
jokes
fact
in
that
the
the
chat
law
right
may
now.
have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life. But the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However,
The worst jury instruction.
Yeah.
That to me that sounded like
you must
he was
consider the law of
opening a
self-defense in
door.
deciding whether
He
the
made that
defendant's
worse.
conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. He does not have a privilege of self-defense as to Richard McGinnis. The
That
law of
doesn't make any
self-defense allows the defendant to threaten or
You would think it should be
intentionally use
lesser
force
than a
against
regular
another
criminally
only if the
reckless.
defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In
So he did wind up
determining
repeating
whether
it
the
at least
defendant's
twice.
beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
Did he just lick his thumb to change the page on his iPhone?
Yeah.
He did say he was bad at that. I mean,
That's
when
weird.
Look, it increases capacitive receptiveness.
You should
Viva.
consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another.
See,
The
that's just
burden
a
is on the
terrible
state
set
to
of
prove
instructions.
by
That's a
beyond
horrible instruction.
the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first degree intentional homicide, you may consider whether or not the defendant is guilty of second degree intentional homicide or first degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second degree intentional homicide and first degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense, the Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life.
Based on the chat, it seems a lot more people are confused now than they more so than they were
You will be
earlier.
asked to consider the privilege of
These are-
self-defense
these are
in deciding whether
torturous
the elements of
instructions.
first degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether.
All right, there you go. There's the jury makeup. They able to find.
Instead, you will be asked to
I don't know
determine
how they
whether the
choose the
state's
12 to go back.
necessary facts to justify a finding of guilty for first or second
I would
degree
imagine.
intentional homicide or for first-degree reckless homicide.
It's 11 women,
If the
8
state
men
does
now.
not satisfy you that those facts are established by the evidence, you will be
I
instructed to find the
bet it's
defendant
probably going to be
not
about
guilty.
6 and 6. I would say that one Hispanic person will not go
Facts
back
necessary to constitute
for
each
safety
crime
reasons.
will now be defined for you in greater
because it'd be easy to identify on the street.
Oh boy.
First-degree intentional homicide is defined in the criminal code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself.
I'm surprised the prosecution didn't
The third
talk
element
about
of the
Rosenbaum's
first-degree,
size.
Intentional homicide requires that the
He was like 5'3".
defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, that this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intentional. If you are not so satisfied, then you must
we're
not
still
find
here,
the
boys.
defendant guilty
I was
of
gonna
first
say,
degree
what's going on
intentional
there?
homicide, and must consider whether the
You
defendant
missed
is
nothing.
guilty of second-degree intentional homicide,
This is also why I usually have graphic text in
as
most of my
defined in the
videos.
criminal code, which is a lesser included offense of the first-degree intentional homicide. There are hierarchies of cases in the law.
Oh, good, a story.
History lesson.
Typically, first-degree.
He knows they're bored.
Highest offense, then lesser
Oh,
included
Rittenhouse
crimes
Young.
Even-
That's it.
that are of the same
Headlines.
nature with many common elements, but some differences.
I take that as a
So, there's
positive.
sequence
Kyle
of
Rittenhouse yawns over the death of his enemies.
This
The fact
count,
he has to explain the
And
jury
that's what
instructions
we're
within the
doing.
jury
So we'll take
instructions
on
is
now
not a positive sign.
Juryception.
Yeah,
Let
really.
me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree intentional homicide, you should consider whether the defendant is guilty of second degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second degree intentional homicide. The third element of second degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to
Is
prevent
the jury
imminent
even
death or great bodily
alive
harm to
at this
himself.
point?
It does make you think there's got to be a better
Judge
way to
needed
do this.
coffee to
This
get
requires
through
that the
this.
state have proved
I
one
mean,
of
to
the
be
following.
fair,
What's he on
this
page
might
First,
also
five?
be
that
kinda
a
boring.
reasonable person in the
Oh man, it's
circumstances
36
of the defendant
pages.
would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death so as to, excuse me, consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you were satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person. A crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilty on a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify finding of guilt for attempted first or second.
Yeah, if you fell asleep 10 minutes ago, the jury fell
The
asleep
state
15
does not
minutes ago.
satisfy you that those facts are established by
Legal
the evidence.
mindset went to bed.
You will be
He'll be
instructed to
back.
find the defendant not guilty.
They have to put
The
this on the
elements of
record,
each crime
though.
will now be defined
So
for
this
you in
way,
greater
on the
detail.
record, it's clear that
Oh, more
Before you may
more
find the
detail.
defendant guilty of attempted first-degree
the jury
intentional
was
homicide,
informed
the
of all
state
this
must prove
information before they
by
reached their
evidence which
decision.
satisfies
So
you
they need to
beyond
put
a
this on the
reasonable
record.
doubt that the following three elements were present.
I'll be right back because I've
First,
already
that the
heard this.
defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill
Coming to
another
the interesting
human being,
instructions soon,
and
the
that
ones
his
that are
acts demonstrate unequivocally
especially highlighted,
that
like
the defendant
provocation,
intended to kill and would
endowment.
have killed the other, except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the
Did you guys
defendant is
notice that
guilty
he
of
changed the
attempted
tissue box?
second-degree intentional homicide.
No,
He
the
did
bruise
change the
was
tissue
there.
box.
That
It
was
used to be
always there.
American
Or
There
you may
flag.
find the
was
defendant
one on the
guilty of
left.
second-degree intentional homicide.
I didn't see that one
The state
before. I
must
only saw
prove
the
by
American one.
evidence which satisfies
saw that
you
one
beyond
before.
a reasonable doubt.
Oh, of course, saw
Following
it
three
before.
elements were present.
It's so boring. You're actually looking around
First,
his
that the
background.
defendant intended to kill another. Second, that he did acts which
I
demonstrate
want to know who gave him
unequivocally
that
under
that
all
Mickey
the
Mouse pencil.
circumstances that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor.
That's why
The
when
third
you're
element
one
is
of
that
these
the
attorneys
defendant did not
trying a
reasonably
case,
believe
you also
that
don't want to
he
be
was
dressed
preventing
too
or terminating an unlawful
in
interference
too
with his
complicated
own
of a
person,
way, because that's exactly what the
or did
jury's
not
going to do. They're going to start
reasonably believe
studying all these
that
details
use was necessary to
instead of paying
prevent
attention to what you're saying.
imminent death or great bodily
Too
harm.
complicated a way is another word for saying
Exactly.
provocative.
Ada in the chat says
You have already
26
been
more
instructed on the
pages.
definition.
Oh my gosh, there's
Do
26
they
more
read the
pages.
jury instructions or anything similar to the jury before the trial starts?
He gave a summary of the charges.
The third element of attempted
No.
second-degree intentional homicide requires that the defendant did not reasonably believe that he was
My mom texted
preventing
me.
or
She was
terminating
like,
an unlawful
"This sounds like
interference with
this
his
feels
own
like a
person,
rosary
or did not
cadence."
reasonably
People are like,
believe
"Yeah,
that
we're
the
all
force
doing our
used
own
was
penance."
necessary to prevent imminent death or great bodily harm to himself.
I was
This
thinking it
requires
was
that the state
catechismal
have
here.
proved any one of the following. First, that the reasonable person in the
I feel
circumstances of the
mostly I feel
defendant
bad for Nick because
would
he has
not
that
have
issue with his
believed that he
fake
was
narcolepsy.
preventing or
I
terminating
don't
an
know
unlawful
how he's
interference
standing up. So
with his own person, or that a reasonable person in the circumstances.
I certainly
of the
understand needing to
defendant
put this in the
would not have
record, but I don't
believed
know
that he
how
was in
helpful it is
danger
as
of
part of the jury
great bodily
process.
harm.
So
Right.
Or that that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is when a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second-degree intentional homicide.
Is your cat asleep
First-degree
too?
recklessly endangering safety as
Yes.
defined in the criminal code is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted.
Someone asked if Kyle can
If
get
you are
time
not so
served for
satisfied,
this
then you must
reading.
find the defendant
Sweet Jesus,
You are
you
not in
should.
any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of that,
At what point does
highest
this
degree
start
of crime,
violating their Eighth Amendment rights?
you need not consider lesser
30
included
minutes
offenses.
ago.
If
You need a
decide
flow chart.
unanimously
You need a
that the
flow
defendant,
chart for this.
did not
You really
commit
do. I was
any
actually
great
thinking
Yeah.
what they need is
and
check
was
boxes, if
acting
then
lawfully in
statements.
self-defense.
But seriously, this is why most of my videos that are non-live streams have text graphics, is so that people can actually follow along, because law can sometimes be very boring.
I
Sometimes.
tweeted this out.
Is he waiting
or-
for the jury to respond?
Yeah, I was like,
Somebody's poking them to wake them up.
Myself, a little bit sentence, I
he
don't
never
like.
mentioned provocation.
Um,
Is he done?
He mentioned provocation.
He did.
Earlier.
Yeah.
I just said
Oh.
I tweeted this out. They should read this to the jury before the trial starts, so the jury can digest the evidence properly, because this would change how they would see the evidence in real time, in my humble
They-
opinion.
But you don't know
But
what the
they-
charges are going to be though before that.
Yeah,
You wouldn't
but
know
it
what
might
the-
be
you
worth
wouldn't
it
know
anyhow. But
And what's in evidence to sustain the jury instructions?
I don't know.
You think
it
they would
seems like
retain
moving-
this information for 2 weeks, Viva? They wouldn't remember this.
I think
I
they
gotta-
would retain enough of it to know what to look for in the evidence being presented to them. Now they have to go and reassess in retrospect, knowing, I agree, they may drop some charges, and so it would be superfluous to read charges that are no longer there. I think it would be value added to jury digestion of evidence.
FSX 239 says At Ricada Law, while I respect your efforts in providing the stream, your panel isn't useful on using this trial as a learning experience due to the extreme bias displayed by each lawyer on the panel.
I'm
to
the
which-
most neutral one here. I understand where he's coming from. The rest
Hold
of you
on,
are
wait.
ridiculously.
Finish the chat there, Nick.
No,
Was that it?
that was it. My response was we're not biased, the facts are biased. But that's my interpretation. I don't know. Does any of you want to say anything about your ridiculous bias?
I will say that accusing someone of bias based on one example is itself biased because you have nothing to compare it to. So one would have to have a consistent pattern of behavior to qualify it as bias and not a one-off. And I can safely say that I've taken positions on other high-profile cases that would contradict any perceived bias in my view of this particular case.
I'll
Yeah,
confess to a
here's a
strong
challenge.
anti-diddler bias. I mean, that's out there, you know.
Here's a challenge. How about, in order to support that assertion, you go and take a look at all of our videos on all of our channels and try to find our bias.
There you
How
go.
about
There you go. We
Dude,
all
because
just got one extra view per video.
I start,
This would be the same person. This would be the same person who watches my Armada Arbery coverage and then tell me that I'm a left-wing lunatic, right? And
Yeah,
then watch
right.
this coverage and say I'm a right-wing lunatic. You know, they don't know anything about what they're talking about. And the fact of the matter is, even the left-wing media is saying
It's
the same
turning.
thing we're saying. So
Yeah.
it's not like we're
Concern
not
that I
saying anything
have.
different, right?
And I worked with the instructions all weekend, and we discussed them by email. And then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury and decided I better talk to you people beforehand is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example. And they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense.
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1 or count 5, I should
I
say,
assume they removed the jury for
and
this.
decide that the
Yeah.
elements are
Yes.
there, but they all decide it was privileged under the law of self-defense. They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's what I used to construct these from scratch.
Oh, good. He'll say it separately. This is a
I
good
would
thing.
tell the jury which I was just
Used
doing
to etch them
now,
into stone.
that once you have exhausted this, you're done.
Once you
As
establish
opposed to having
self-defense,
to
you're done,
needlessly go
and he's
through
free
these lessers if they've
of that
already
charge.
concluded,
That simplifies
and this
things,
is a
which is
case where
not what
this
the
could happen.
prosecution
I'm not
wants, but is
saying
the way that it
should or
should be.
won't. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of valid self-defense, then they really should not be considering
The lesser includes.
lesser included. Am I right or wrong about that?
You are
So
correct.
if they find
We all agree.
perfect self-defense on the charged count,
Just say
Yeah.
self-defense.
they
Right.
should be told.
You see what this?
Well, the other counts
Yeah,
are not
I'm sorry.
guilty.
I mean, I understand
The obvious
where the court's
answer
coming
is yes.
from.
Obviously,
I guess
this
they
should
could
happen.
consider the other ones in 30 seconds and just go down to be not guilty.
I-
But
They're so complicated as it is.
Thank you.
I feel
Yep.
I feel terrible about doing this kind of stuff.
Cross is like, that's the way
It's
we wanted it.
Just so well. Anyway, see what the instruction is telling them that kind of cryptically. It says if after it tells them if after a full discussion.
I think what's really going to make things easier to understand is going back and changing it now after having them leave the room.
Yeah, that'll be good.
But it's good
if
in
we
that
could somehow make this another hour, that'll really help.
This is
I'll
this
tell
is
you, I'm
the
happy to do it.
congressional problem, right? Like this is the problem that Congresses have when they name a bill one thing and then they lump in a whole bunch of other stuff, and it's like eventually everybody's
Says,
eyes
however,
glaze
if
over
after a
because it's
full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide. I'm going back to a different count. You should consider whether the defendant is guilty. So it is telling them. It is telling them. Yeah, I just think it's kind of unclear.
I think it's very clear. What you're saying is wrong. They all agree the elements are met.
Say
and there's a
properly,
privilege.
Richards.
You don't go any further.
This is great having it separated.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward. They going.
Where does it use?
Don't have to, but prohibited from going forward. That's what they need to be told.
It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide.
That's just
However,
the charge,
if
not
after
the
a full and
defense.
complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone did deliberately is trying to make things
One of the
unclear.
biggest
That's what
problems
lawyers
with
are for.
What's funny is you wrote it, right?
Don't do that. People will find out our lawyer secrets.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessons.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once
point.
they've discussed the highest count,
I don't think
if
they
they
should
are
include the
unanimous.
unanimous statement on
Either way.
self-defense personally. If you
Then
find
they're
self-defense,
done.
then don't include the lessers
Does that make
Period.
sense?
Mhm.
No, Mr.
individually.
Binger's having a problem with that, and let's see where he is.
Mr. Finger's having a problem with
Hmm.
that.
I don't like.
He was
the way I
making
said
Binger
that either.
face.
What's his lapel pin today?
Oh God, the lapel
This
pins.
judge needs to stop reading the news. That's what he needs to stop doing. The judge should have sequestered himself like he asked the jury to do. Because there he just checked himself on Mr. Binger has a problem with that. Oh, I don't like the way I said that. And he looked up pensively like,
No,
shit, that's going to be in a CNN headline.
No, I think he meant he didn't like the way he said what he was phrasing as the new jury instructions. Or did he?
No, I think it was his Binger
think is that-
statement.
I think that's
Yeah.
right.
Yeah, he's regretting the whole Asian food comment.
Which
And
you
just,
shouldn't. If
Yeah,
your
you
Asian
shouldn't at
food
all.
is sitting off the harbor in California, you definitely don't want to eat it. It's been there a long time.
Right next to the Oriental rug.
Oh, here we go. Sitting
You
here
did it.
next
You
to-
went there. Very uncouth.
Yeah, Mr.
How about this?
Superhuman over here
In any
weighing in
count
with his
where,
comments.
in any count where there are multiple verdicts submitted to you, if at
No.
any point in your deliberations you are unanimous either as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
Boom.
The reason I
Okay, and
is because let's take Anthony Huber's counts, for example. If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
what a
Only if
sneaky-
they're not satisfied that it was done in self-defense. If they, for example, if in your example,
This
if they
eliminates the lesser included
discussed it and
altogether.
said, well, sure, the elements of attempt murder are there. And then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's.
See, I think one of the
actually,
things that's
if
happening
they
here
all
is
say
that
we don't
the
think it's
statute itself
self-defense,
has, as a
then
mitigating
it's not
circumstance,
guilty.
something that looks a lot like
And what the
self-defense
jury
that
is being
kicks
told
folks
is if
down
you
to
can't
second.
agree
But there's also a
unanimously,
privilege, what I think the
then consider
prosecution
these
keeps referring
lessons,
to as
but I don't
perfect
think it's so clear
self-defense
as it should be.
that gives you the right to do all of these
As
things.
if you are not so satisfied.
I know it. Well,
Um,
that's at the very end.
I think what the court was originally proposing is telling the jury unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on,
So for example,
if you're unanimous on the legal question,
Back that up, Binger.
intentional.
Well, he's
well, you're
disregarding
right,
the
because it could
self-defense
be an elements
qualifier.
issue.
Yeah, Binger's saying
Maybe the construction.
Binger wants clarification
jury
that it's
only goes to
self-defense
lesser
only.
included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count, then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But
I
that's
do
not
think
true,
this is
because if
useful
they're
for showing
unanimous on
people how
first degree
messy this can
intentional
get on the
homicide,
ground.
what they're concluding at that point is that the defendant, either the elements aren't met or the defendant actually believed that deadly force was necessary. They would still then have to consider the secondary intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first degree intentional homicide. They can be unanimous on that and in the defendant's favor, but they still have to then move to the second element or to the lesser included.
That doesn't make any sense.
How would they
No.
find no
You're right.
self-defense on assault, but yes, self-defense
Pardon
on
me?
murder?
Because he doesn't have to be reasonable for first degree.
Yeah.
He gets
Yeah.
kicked out of first degree even if he's
Defense
unreasonable.
on first degree intentional homicide. They're specifically told
Well, yeah, you're right. He's right.
they're not told to consider that until second degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But
Maybe we could.
I'm sure we could, but we need to follow them. And I don't
Well, I
think
think-
deviation
I
is
think you're
appropriate.
right. I think you're right. And they are certainly correct in what they say. I just think that they're not.
No, I think the prosecution's
clear,
right, but I
but
think it's
maybe-
because
maybe
Wisconsin's a
they
little
are.
weird on these.
Now, let's see how
Yeah.
much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Can we rewind the tape, please?
Shoot, I'll be right back.
I like the fact that provocation got lost in the middle of those instructions. Rather than being highlighted at the end.
It's good we haven't heard it yet, and it's not being repeated over and over again.
Several
Now,
of
hold
us
on a
never
second. By the
noticed
way-
that it was there.
Chat. Let us know if you think Judge Schroeder said I don't like the way I said that in terms of what he said about Binger or how he phrased the new instructions. Because having watched this now, I think he said I didn't like the way I said that in terms of how he rephrased the instructions. But I see how Nick might have heard it that way.
Defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right.
That's what I thought.
Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over.
Yeah, how do you get assault or something
Yeah.
from that?
Yeah, what were you saying, Rick?
I think that's correct. Even your suggestion is seductive, Mr. Binger. But
Yes, he's always wrapped
if
around
they,
his finger.
but see, they're not asked to consider that. That's where I'm having the problem.
I think the judge really is
Yeah,
mixing up
you
the
know, and
mitigating
they even make
circumstances
reference to
prong
it.
and the privilege prong.
They even make reference to it. I think maybe I read one of the comments. They talk about we don't have.
Actually
like some
see what
states
Binger
where
is
they have a
saying.
question right off the
But I
bat.
distrust
was
his
the defendant
motives
acting
anyway.
lawfully in self-defense? They answer
That's,
that yes,
that's fair enough.
we're all done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury? Tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's
Correct.
over.
He should say that.
I understand what
That's right. That's the
perfect
privilege.
self-defense means, but we haven't told the jury what that means.
Tell him that.
We're deviating from the standard instructions here.
So
And
what?
The words perfect self-defense don't have a meaning to ordinary people.
Actually,
Would require
I would
further definition
suggest
from the court, and now
that
we're
Singer
going
does not
much
know what
further
perfect
afield.
self-defense means.
I also have a problem with
Or else we wouldn't be here.
the wording of, do you find, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide. And then we've given them the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court reporter doesn't delineate between those two things. And I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the objective. The final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well,
So again,
it is if you're talking just about an individual count.
But I was saying blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing a count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's
He always
causing
cuts the
confusion.
judge off.
What the Madam Court reporter just read back, for example, could be construed as saying,
And Schroeder lets him get
anytime
away with it.
with regard to any count you find justified self-defense, he walks on all 5 counts, and that is absolutely not true.
That's not
That's not what he said.
That's not what
Nobody
he
said
said,
that.
and that's not what he's suggesting.
Tell that, but what's
That's not
already
even
been
close to
said
what it was said.
gives that implication. And again, I just
No,
worry
it
that
doesn't.
the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them, and I
Placing
am
blame.
leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well, and I can say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than most, than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty. And I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense.
That's
There you
even
go.
better. That's even better.
Instructed on that. So I think the correct statement is, if as to
Yeah, because
any
perfect
of the
self-defense, I think,
cases
means
with
something different to the jury than it does to
submissions,
most
if
lawyers.
on any individual count, they find
Am I the only one? It sounds like he's asking Bingo permission
consideration
rather than
of
just
the
making a
charge of
decision for
defense.
A
himself.
little bit, yeah.
the defendant
But
acted
he has to get
lawfully in
both sides to agree though
self-defense,
before he,
they're done.
And he knows Richards is down.
Or a risk
Objection.
reversal.
Okay.
Look at Binger.
jury
Look at Binger.
instructions.
Yeah,
It
can't
was
even
noticed
concede with
as you
pride.
read them on page 10, which is
Salt
count
incarnate.
3. It should be first degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
But on page 10,
on page 10 on count, still at the end of
no.
count 3,
Typos in the
it
jury
says you
instructions?
should
That's not
find the
good.
defendant guilty of first.
yeah, you're
degree
right. You're right. It is in there as homicide.
And someone was asking
we
if they're
didn't
gonna have
catch
a
that
copy of
last
this
time
in
we
the
talked
jury
about it.
room.
I sent you 3
I
drafts.
think so.
Yeah.
But you know what?
I would
Should I
hope
just
so.
leave that alone? They'll know.
They
that.
have to.
I'll change it in the
Yeah.
printed copy.
There's no way that they can follow
In the-
all of this.
I'll
just by
change it
listening
in
to
the written printed copy. He just said.
Okay, yeah, they
Serendipitous
actually are.
timing.
After
So,
11.
so they are going to get it.
How long are you gonna talk in your first sequence?
Try and limit myself to 2 hours.
Are
Try.
you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon because the lunch is already been ordered. So I'm not
It's
gonna-
lunch being ordered business.
Love it.
Don't want cold lunch.
Law and Crime stream just got suspended for policy violations.
So let's ask the jury.
What's the policy?
So I'll take
I
a
don't
break
know,
and-
but I got a
why don't you
warning that says
around
heads up,
whenever
we've
you're
detected
comfortable, around
copyrighted
noon,
audio in your stream. Your audio may
uh,
be temporarily
just ask
blocked,
for
or your stream
Oh,
may be
no.
temporarily blocked.
It's because
I
we've got
assume
talk
Law and
over it.
Crime,
He's the commander of the.
Law
I
and
don't wanna
Crime got a
interrupt
similar
him if
thing,
I
I'm guessing.
want to be.
Well, if we
Oh my
continually
goodness.
talk over the original audio, then you should be safe on that.
We'll
Yeah.
just get a lot of
That happened to me
complaints in the chat, but you know.
That happened
I don't know.
with the Chauvin trial. With the Chauvin
what-
trial, I
what's-
don't know what it was like. Maybe a ringtone or something, but it happened to me too, and they cut my stream. Then I had to
Oh
redo it. So
no.
it does
It
happen.
was
So-
the judge's pew
so-
pew pew ringtone.
Oh yeah, probably. So to clarify, what they were just discussing was how self-defense works with these other charges and whether or not they can dismiss the lesser included charges if they found self-defense. And it sounded like what Binger was saying that it sounded like Binger thought that the judge was proposing that if they found self-defense for one of these incidents, for one of these charges, then they found self-defense for all of them. And that's not what he was proposing.
So, folks, what I was talking
So,
about.
but
with-
it
with the
sounds like
cases that
they
you
finally
have,
came to an agreement, right, guys?
multiple
Sounds like
possible
it.
verdicts submitted to you for consideration. When you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that?
I don't think the state
It
can like how that
hopefully will
wound
become
up
clear. I'm
sounding.
going to give you written
Makes it very
instructions.
easy for them to quit this.
Yep.
Yeah.
Because I know this is arduous going through this, but every bit of it is important. And but you'll get written instructions for your
Not to mention that
reference
long
in,
break basically highlighted that
considering
now.
these things.
Kyle's trying his best to stay awake, and I mean, everybody's gonna be posting pictures of him yawning, going, "Oh, look, he's such a bad
Yeah.
guy" or whatever. But how do you stay awake during something like that?
Counts
Yeah,
1
we're-
through
we're all
5.
bored during
that's
these
all
jury
the counts are.
instructions.
Each contain the guilty verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find the answer, answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life.
I never think they give enough emphasis on what beyond a reasonable doubt means.
Speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit.
I was talking, I had the mic muted. That's not my stream that got hit. I will stop this though. Let's see here. How do I stop it? I cannot believe they hit Nick Rakita. Holy cow. That guy had 90,000 viewers the other day. He was on Glenn Beck's show. Talk about this. The guy he's got, I think 30,000 more. So he had like 30, who is it? PBS has had the most live stream viewers on here of a main channel. And PBS had like 66,000, something like that. Rakita had like 90,000. He was hoping to break 100,000 a day. And they just cut him. Wow. Oh my gosh. I would love to hear what he's saying right now. That can't be it. I'm trying to find it. Wow. I don't know. He's off, man. They took him off. Let's see here. This.
I switched windows and it worked.
Only so much of a statement as was actually made.
Well, I got the tweet out in time. It's
That's
funny too
weird.
as to how there could be privacy
Whether the
violations
statement was
during a publicly
accurately
broadcast
restated here at
trial.
the trial, whether the statement or any part of it ought to
Oh,
be
wow.
You should consider the facts
It
and
only knocked off
circumstances surrounding
30,000
the
live
making of each
viewers.
statement, along with
Jesus.
all other
They'll
evidence
be back.
accompanying
Did you hear that?
the statement.
Yeah, let me retweet. Let's retweet this thing back.
Yeah,
up.
I'm
The weight of the evidence does
Tweet this
not
out,
depend
too.
on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering.
Uh-oh, where'd mine go? I just turned mine off. Because I'm an idiot. No, they still got him off. That's not me. They did. They cut him off again. Holy moly. Oh, man. This sucks. There were 47,000 people watching him when he got cut off. It still shows him. Nope, stream unavailable for policy violations. Oh my gosh, dude. I love it when they cut off a stream full of lawyers. Oh my gosh. What a joke, YouTube. Come on. Oh man. Yeah, I agree with him. So he's got you cut off my stream. The two parts all that remains. I agree with that. Wow. What a joke, man. What a freaking joke. Well, I mean, so they cut off closing arguments. This is a publicly streamed thing. Legal Mindset. Live in 7 hours, so he's going to be on afterwards. Holy cow. This is a joke. Man alive. Go Fox Milwaukee, so they have. Yeah, they are showing it live. Hang on here. Oh, man, what a joke.
And we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning?
I'd start
the
fresh.
cutoff point would be, say we got finished by 4 and I give you the case. The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up anytime after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2, 3, 4, 5, 6, 7, 8. 8 out of, what do we got, 18? How many would rather come back fresh tomorrow?
Yeah, you gonna leave right now?
Some of you aren't coming back. Okay, and of course, as always, I'll make the final decision, but
I love
certainly
it.
will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge.
All right, here we
Good morning,
go.
ladies and gentlemen. I want to assure
Here we
you that
go.
everything that the judge just read to you, you'll get a copy out, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Oh, they're objecting already. Yes.
Curfew charge anymore. There's no gun charge.
Although he claimed
there's no charge, but and there
he objected.
There has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. So it's there, but there had been a curfew announced. That does not mean that it was technically lawfully.
Dude, you're helping out the prosecution here, so nobody can say he's not fair.
And it was a curfew that all the rest of us here in Kenosha were aware of, and I think most people, most reasonable people, obeyed.
Most reasonable
Although
people.
the defendant claimed to be protecting.
So what do you call the Black Lives Matter people? They're not reasonable. He just called Black Lives Matter unreasonable.
In this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what were his true motivations were. Was this a situation where he sincerely cared about Car Source, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters.
He lied
So
on a
why was he
stupid
there
cell phone
that night?
video. You realize that, right?
When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized, and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here.
It
We
was
have
a
all
war
agreed,
zone.
and I asked you this
War is
2 weeks ago
hell.
today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't
Well,
get to
then
kill
you're all
someone simply
pro-life,
because they're
huh?
a drug dealer. You don't weigh a pastor's life over a teacher's life.
Oh,
You
I
don't weigh a
would.
police officer's life over an engineer's life.
Oh, an engineer every
All
time.
life
Ah!
is sacred. I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s.
Why?
Because this is exactly what happens.
You didn't do.
And
How
finally,
many Black Lives Matter
I want
people
you
did
to
you
keep in
prosecute?
mind that we've all read stories and heard about heroes
How many got
that
prosecuted
step
the
in
entire
to
year
stop
last
an
year?
active shooter or to give their
The
life
entire
to
summer.
save others.
Not a one.
In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them.
No, they didn't. They got
So
it
when
because
you
the police
consider
gave up
this
on
case,
them.
Look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't
Did you
have any
see
of those
that in the second
preconceived
one?
notions.
Whether it's heroic
Now
to
you've heard the
provoke
evidence, and it's time to search for the truth.
unarmed
So
person.
consider, for example, whether or not it's heroic or
Period.
honorable to provoke and shoot unarmed people.
Should you provoke an armed person
Whether
then?
it makes someone a hero when they lie about being an EMT.
Those
I think
two things
all
don't.
of us are familiar with someone who does the sorts of
quite.
things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up. and without the legal authority to do so.
There's no.
And when you think about the defendant's
Nothing on any
behavior
of
in this
that.
case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives.
A commie.
So when I talk to you
an
here,
admitted
in
communist,
my closing argument,
they don't save lives. A
I'm gonna
communist has
focus
never
first
rushed to save
on the
somebody's
murders
life.
that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you.
John Smith, it is all about
Prosecutors in this
politics.
case,
It absolutely
my colleague
is.
Jim Krause and I
remember,
have
you're the
tried
one
to
that's going to
present
be on
you
trial
with
here.
all of the relevant
All of
evidence
America's on trial.
that we think
This is
we
a
should
this is
consider
the
in
first
this case.
step. If
And
they
I told
get
one of you
a
in jury selection that at the end of
so
this,
you
you
put
would
a
be the
gun to your
expert.
head.
You would have all the
Yeah, she
information.
do.
You would be the one who would know all about this case and make that decision. And that's what we've tried to do.
Yeah, see, I lost my thing here. Hang on.
So let's go to August 25th, 2020. The defendant came from outside our community carrying a gun that wasn't his because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met.
Oh yeah, shoot first.
while fraudulently claiming all night long.
Yes, I
to
finally.
be an
It took me
EMT.
3 times to read that. Sorry. I don't know what's wrong with me.
There were a lot of people out that night. Some people stayed home protecting their homes and their families.
Yes.
Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along. to
Kyle's a
protect car
rooftop
stores,
Korean.
Ultimate Gas, or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with
clash.
AR-15s at Ultimate Gas and other folks that are, I guess, protesters.
I guess
And there's
protesters?
People getting in people's faces, they're yelling, they're
I
shouting,
guess
there's even
protesters?
shoving.
What were they protesting
And
there?
yet, in this entire sequence
Burger?
of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through.
The police weren't there to help anybody either.
Shot and
National Guard didn't stop anything. That's why he had an AR.
No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Zeminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson.
Notice how he's got his
So let's
voice
keep
sound
that
like
in
he's
mind
talking to a kid.
when we're talking about the people involved in this case.
When you talk to people, talk to like the jurors and stuff,
So
you're
let's
supposed to do
begin
like a second grade
provocation
education level.
and the
Like you're
murder
talking to second graders.
of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street car source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant.
I think
The
he
defendant
was.
arrives at that location, and you hear him yell, friendly, friendly, friendly.
Yeah.
Because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is
If
when
he
you
really
hear
needed to,
someone,
he wouldn't need his left hand.
I think the testimony is Rosenbaum, it's not clear to me, but either way, yell gun, gun, gun. And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun
Oh my
or
God.
shooting anyone.
How can you make Rosenbaum look
So
like a
let's take a
hero,
look at
you
some of that video.
asshole? John Smith, I can't
This
stand
is
him.
Exhibit 73, the full
Can't
drone
stand him.
video.
Yeah, we did.
And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that
Is that
scene,
Biggie
the
Smalls?
first thing you see him do is drop the fire extinguisher and point. his weapon at people. And then
Point.
the chase occurs right after that.
I
And you're gonna
object
see
to
that entire
his
sequence of
language
events
here
on
because
the full
by
drone
talking like
video.
that, he sounded like he is saying that he was pointing him out, like he was targeting him. That was a very, very deliberate thing. Point his weapon up, and we don't even know where this file here came from. This just showed up. And by the
Lieutenant
way,
turns as
see
he's
here.
being pursued. And
But you
points
look
the
over
gun at
here,
Mr. Rosenbaum.
like the
And
next
then as
guy
he
gets
enters
shot.
the area between the parked cars, he slows.
It doesn't
and
look like
turns,
it.
and
It's like
before
a.
Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground.
One, I love they have the volume turned off because there's a shot before the 4 shots Kyle makes. Then there's 2 more shots. And didn't that look like a Hollywood production right there? It just happened to show up 2 days before the.
Now I'm going to show you the slowed
before
down
this.
and
Last
zoomed
Friday
in
showed
video
up.
of the defendant when he first gets there. And Mr. Krause is going to help me by
Weird.
directing your attention on the larger screen here to exactly where you will see the defendant.
Play the volume. We don't even know who took this film. Let's go down here to the sign. And
I'm
look.
going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground
I don't see it.
with his left hand and then brings his left hand over to the gun and raises it and points.
Where? I totally don't see it. Are they trying to see way back here? I don't see it, man.
Make sure it's empty.
You have to point that one out, bud.
Under Wisconsin law, you're not allowed to run around and point your gun at people.
Oh, you're not allowed to run around and
Provocation.
punch a gun at people.
This is what starts this incident. The defendant rushes in.
Oh my
and
God!
immediately points the
Go
gun.
bust all these people in.
And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns.
Oh, because he's a hero, Rosenbaum. He raped 5 boys.
That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28.
Yeah, it's in evidence. It's in evidence.
I'm having the detectives check it to make sure that it is safe.
Did anybody check to see if the site was 0? I mean, it's
The
point
defendant
blank.
comes running in.
Point
and
blank
drops
while
the
running
fire
away.
extinguisher on the ground like this.
Oh, yeah.
And then raises his left hand to the gun and points. This is
What
what we see in the
asshole.
video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to check. He's facing the wrong direction.
That's an argument.
Okay.
That's an argument. That's it. You're facing the wrong direction. That's an argument.
I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up.
What an ass.
You can see it again on the video here. His left arm reaching up towards the gun.
Where? I don't see it anywhere in that video.
That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one
He ran
who's
away.
threatening others, you lose the right to claim self-defense.
Yeah, but you okay. What he's saying
Then we have the
technically
chase
is
that
true.
occurs after that.
However, you can also
And we have taken that
regain
drone video,
self-defense
and
too.
we have slowed down portions of that chase for you.
Well, that's good. I never
So
saw
what we
what
have
you're
right
talking
here
about
on
the
the
last
screen-
time, asshole.
This is exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant
The
turns
plastic bag
and
is what
points
had
the gun
his
back at
possessions
Mr.
in it when he got out of
Rosenbaum.
jail that
And this
day.
is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air.
Oh, he's just
And the
hopping.
defendant
He's
has
hopping
testified.
along.
He saw at
Tiptoeing
that
through the
moment
tulips.
that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs.
Yeah, Rosenbaum
Mr.
never
Rosenbaum
stops.
is not even within arm's reach.
He
when
never
the first shot
stops.
occurs. I'll play that again. The defendant
So
is pointing
now,
the gun at
because he
Mr.
pointed the
Rosenbaum,
gun,
Mr. Rosenbaum raises his arms off to the side.
Rosenbaum has the right to
The
chase him
defendant
down.
approaches these cars and slows down.
Rosenbaum had
turns
no.
and
He
shoots
provoked him
Mr.
at
Rosenbaum.
first. He started chasing after Kyle. He said because Kyle flashed the gun. Now Kyle lost his right to self-defense. Rosenbaum never
Finally, I'm gonna
stopped.
play
Oh, a
you
little
Exhibit
hop,
86.
maybe. That's what he's trying to say, I guess. I hope he just stands up there and does the Joe Pesci and
This shows you the final part of
My
that,
cousin
zoomed
Vinny.
in and slowed down.
Yeah,
Here's the
everything that
defendant
guy just
running
said,
in between those
bullshit.
parked cars, slowing down, and you can see just how close, or rather how far away,
Far
Mr.
away.
Rosenbaum was when the defendant shot him.
Rosenbaum has burn marks on his hand from trying to grab the muzzle of the rifle.
You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off.
Prosecutors are supposed to
The
uphold
defendant fires
justice.
4 shots.
This
in
guy is
quick
political.
succession.
He should be
And I'll come
fired.
back to this in a moment, but you'll note during this entire sequence,
I don't know if he's a
it's
good
the
attorney.
defendant
Right
who
now,
chooses where
he's
to
not
go.
good in the courtroom. He
He's
is
the one
not good in
who
the
decides to
courtroom.
run where he
Maybe
runs.
he's a magnificent writer.
And he slows down right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well. This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach running in the same direction as Mr. Rosenbaum. This is where the pointing occurs in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there.
And the FBI has planes flying overhead.
The
Can you
defendant is
believe
pointing
this?
his gun right here, and he's pointing it in the direction of the Zeminskis because they're standing next to that car.
Yeah, they just hang out.
And then the chase occurs. Now, what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum. And I'll come back to that in a second. Finally, I'm going to show you this incident.
After the
from
shooting, he
the
turns back
perspective of
around.
Drew Hernandez,
And it
because
looks like
he
he's
is
trying to
behind
offer
all of
help.
this,
Like he's going to go back there
and
to
then he
help
comes upon
Rosenbaum,
Mr.
the guy who wanted to
Rosenbaum's
rape
body.
him earlier in the chase.
Is that audio playing? Why is the audio not playing? Is it coming? Why you're not hearing any audio? Is Brian around? He's not.
With Ryan around, so he's not. This guy thinks he's moving to Hollywood after this case. He's gonna become a big Hollywood, TV attorney.
At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items. Then you can make that dispute in your argument.
It's argument, and you'll be allowed to respond.
I love that he
You
objected
can see
to
in this
that.
video the crowd is.
Why is he
attempting
masked
to
up? Why did he
save
take his shirt
Mr.
off and
Rosenbaum's
wear it
life.
as a mask? Because he's going after Kyle. You ever think about that one? They're gonna just show this guy dying in front of the jury.
So, we have shown you.
My question would be: do
defendant
you think
murdering Joseph
Rosenbaum's in
Rosenbaum
heaven, or do you think he's in
from
hell?
3 different angles: the drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant.
Alleged.
I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of.
Doesn't mean it didn't
I
happen.
have the video of the entire incident. I've played it for you, and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum ever wanted
Let me think about this
defendant's gun. He never said, "I'm going to take your gun." He never said, "I want your gun." There's no indication of that.
Oh shit! Well,
Dr.
just go.
Kelly has
I'm gonna go
testified
take a
that
car.
the first
I'm gonna go
shot
get me a
that
new
the
car day.
defendant
I'm gonna go
fired
down
at
here,
Joseph
BMW. I'm gonna get
hit
this.
the
I'm gonna go get in
victim
there and
in
drive
the right
off with it. I'm not gonna say anything to
structure.
anybody. I didn't steal it because I didn't
Mr.
tell you I was
Rosenbaum
gonna take it.
incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots.
That's a natural
A second
reaction.
shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot.
Oh,
that is
that's
the
a
one
kill shot.
that took Mr. Rosenbaum's life.
I don't think it was.
There is no evidence
Wow.
that Mr. Rosenbaum was reaching for the defendant's gun.
So when you defend yourself, they're
And
gonna
after
see
that first shot, there's
in
no
3
way
quarters of a
Mr.
second.
Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This
Yeah,
is
that was
that
actually
wound.
slow shooting.
Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area.
Yeah.
Tearing through bodily organs and killing Mr. Rosenbaum.
Do we know for a fact? I know he got stuck in his ass.
Here's a picture of the wound to the hand.
Oh.
There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward, with his thumb to the ground.
Look at
when the wound
Dildo here. He
goes
can't even
through
turn his arm around.
the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot. The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense.
Look at Agent 47 over here.
First of all, this occurs after Mr. Rosenbaum has been shot in the hip. And has
okay.
got a fractured pelvis at that point.
Yes, that's why he's trembling.
He is not able to walk. He's probably not even able to control much of his movements at this point.
Oh, really?
When you're reaching for that gun,
Why didn't he
this
stop?
is not
Why didn't
the
he
way
stop after being
you're gonna
shot?
do it.
Why did he not
This is
stop
not
after being shot? You're
going to
complaining about Kyle kept on
I
shooting.
submit
Well,
to you,
why
ladies
didn't
and
this
gentlemen,
asshole
that to the
stop
extent
after
Mr.
he was
Rosenbaum's
shot?
hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional. Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way.
Maybe it did, and he didn't know it.
He didn't think the shot came from Joseph Rosenbaum. He
Yeah,
knew Joseph
the mistake
Rosenbaum was
him going
unarmed,
to trial
and
on
he
the stand.
admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then,
what about his discharging a firearm? You're not charging him with discharging a firearm in public?
The Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man.
He brought
this
a
is
gun to a
This is a
fist
fight.
fight.
This is a
Holy
fight that
did
many,
they
many
just
of you have been involved
show
in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, or whatever.
Roadhouse? Did
But
they
what
just
you
show
don't do
Roadhouse?
is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill.
He should have
So
armed
I want you to
himself.
contrast this. Two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree.
Kyle's
you
not
can't
old enough to
kill
go to a
someone.
bar.
You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder.
I gotta stop for a second. I'll be
So
right
what's the
back.
difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told
At
you
the beginning of this,
that
you
he
said
thought
he
Joseph
brought a
Rosenbaum
gun that
was
wasn't
gonna take that gun
his.
and not only kill him,
Object,
but
object,
kill other
object.
people.
You said he
Which is
brought an
really
AR-15
ironic,
that was
considering the
not
defendant is the
his.
one who killed
Now you're
people in this
saying
case.
he brought
The
his
only-
AR-15.
But
Which one is
putting
it?
that aside,
Which one
they have
is
to
it?
convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp. At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired, as if that somehow excuses him. Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger. He is in control of that decision-making process. No one else made him do that. And this is indicative of someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going. And as I said, he tracks the body all the way to the ground with those second, third, and fourth shots. The only way that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened. That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun. Because if he's not reaching for that gun and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim. One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one who chose where to run. He chose to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause if that's okay. Okay, thank you.
Please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at it's 1:45 too soon? Did you say 12:45 or 1:45? Oh, well, I thought we'd have a leisurely. No, how about 12:45? Is that a better idea? Let's do that. Please don't talk about the case. All right, when we get to the point of reducing the number to 12, we have to decide what to do with the other 6. And the alternatives would be to just let them go about their regular business, and tell them we might call them if we need them. Or we can keep them here, where they can sit and watch daytime TV. I don't know. They have to, obviously, there are limited channels they can watch. And of course, they will not be permitted to talk about the case. So, any preferences?
My preference is to keep them here.
Yes, okay, we'll do that then. And we'll have to find some way to entertain them. Make sure it doesn't involve some of the channels that are available on television. Okay.
12:45, Your Honor?
12:45.
Now my mic's muted. It muted my mic. I didn't mean for it to because I had a great rant that you don't run. I'll be back, probably on Twitch. I'll send a link out on Twitter. Love you guys. Peace.